The contracts question from February of 2000 is another complicated UCC problem. Here's a hypothetical that's going to require us to find a home for all of the details in order to be able to reply to the questions presented. Have a look at the call and you'll see what I mean. Question 1. How should the court rule on the motion for an order staying the trial and compelling arbitration? Discuss. Well, we can't outline an answer to this question without really reading carefully. Arbitration is not a very conventional issue. It isn't something that comes up very frequently on the essays, so we're going to have to analyze what's presented and come up with a reply. The second call of the question is by far the more conventional, and one might expect this to have been the first call, the arbitration issue being an afterthought. Have a look at call number 2. What are the rights and obligations of seller and buyer, and who should prevail on the merits of the litigation? Discuss. Well, now we know that we're dealing with contracts, and we are dealing with the UCC. Seller and buyer almost certainly are merchants, so our mind flashes to a basic approach to contracts. The litigation between the seller and the buyer will require us to consider formation, defenses to formation, performance and breach, and then remedies. And we know under the UCC that damages are by far the preferred remedy. So with all of that in mind, we go up to the top of the question, and we see right up front that this is going to be a question that is densely packed with facts. In paragraph 1, we learn about the negotiations between buyer and seller, and we see them reach an agreement. And the result of this paragraph is the arbitration clause becomes part of our consciousness. We've got the buyer accepting an offer from the seller by placing an order, and this order contains a standard arbitration clause. So between merchants, we know that the most liberal rules about contract formation apply. So where we have a merchant tendering an acceptance that is not a mirror image of the offer, the non-conforming terms automatically will become a part of the agreement so long as the other merchant doesn't object and so long as the new terms don't materially alter the relationship between the parties. Now, we wonder, would an arbitration clause constitute a material change to the agreement? I would answer that question, no, because the parties still have the same rights and obligations, and ultimately the case could end up in court if the arbitration failed. So we look at paragraph 1, and my assumption is the arbitration clause probably is valid. But many of you probably looked at this paragraph, spotted the issue, identified the governing law, and concluded that an arbitration clause, in fact, would be a material change to the agreement. So you don't have to agree with me. If you disagree, your answer will be the opposite. But we are being tested on our ability to spot the issues and to carefully analyze the facts. Here we've got what appears to be a gray area. And so, right up front, one could conclude one way or another with regard to the arbitration clause. But don't set your judgment in stone. There's another fact down the road that's going to affect our analysis on the arbitration clause. But ultimately, we do appear to have a binding agreement between merchants. The subject matter is tires, and there will be a series of transactions for us to consider. We begin with paragraph 2. Here we've got a driver of the seller arriving with the first shipment. The shipment conforms to the buyer's order, but the buyer doesn't pay the driver. And remember, payment is due upon delivery pursuant to the terms of the agreement. The driver leaves, the buyer has got the goods, and then a few days later, the buyer makes a payment and places a second order. We see the driver arrive with that second order. That order also complies with the buyer's requirements, and then again the buyer doesn't pay the driver. And a few days later, again, the buyer tenders payment. So at this point it appears as if the course of conduct of the parties has changed this agreement a little bit. Once the parties begin to perform, assuming they don't exactly conform to the terms of the agreement, then that new modified agreement based on the conduct of the parties will apply. So now we've had a couple of occasions in which the seller has accepted a late tendered payment. we can conclude reasonably that the seller has waived the right to be paid immediately upon delivery. In paragraph 3, we see the buyer, again, tendering a late payment and specifying a third installment. Now the driver arrives with a third delivery, but this time the goods are non-conforming. The buyer accepts the tires anyway and then pays for the third installment about a week later. So now we've had 3 transactions. The first 2 transactions conform to the buyer's requirements. The third doesn't. All 3 times, the buyer tenders payment late. So at this point, I think we can reasonably conclude that the seller is not entitled to immediate payment, whether or not the buyer has waived the right to reject non-conforming goods, I think is another one of those gray areas. I'm going to conclude that the buyer hasn't waived the right to receive the goods as ordered. Now, in paragraph 4, we see the latest delivery. Here the goods are non-conforming and the driver demands immediate payment. The buyer can't make the immediate payment, and so what happens is the driver leaves without leaving the tires and without obtaining payment. Now the buyer calls the seller and inquires about how their relationship is breaking down. Buyer says that he wants the goods that he ordered and he wants to pay for them a few days later, as has always been the case between these parties. Seller refuses and, importantly, suggests that the buyer initiate an arbitration. So here we've got a situation where the seller is acknowledging the binding nature of the arbitration clause that the buyer inserted into the agreement. So thinking back a few paragraphs, when we first looked at the arbitration clause, we wondered, does it materially change the relationship between these parties? Because if it does, it won't become part of the agreement. But here, several paragraphs later, we see the seller relying on the arbitration clause. So at this point, I think we can conclude reasonably that the arbitration clause, in fact, is a part of this agreement. And so our answer to call of the question number 1 is yes. Although obviously we're going to have to do a little bit more than write one word saying that the court should grant the motion. We're going to have to explain the evolution of the relationship between these parties, focusing on both the rules and the facts in order to reach that conclusion. Then in the very last paragraph, we see the lawsuit. Seller sues buyer for breach of contract. Buyer files a counterclaim and seeks an order compelling arbitration. Seller opposes the motion, and then we get the call of the question again. So we've got a tricky question factually, but legally, this actually is a fairly simple question. So let's have a look together at the outline of issues that I've presented. You'll see right from the beginning that my answer to the first call of the question goes into a fair amount of depth. First, I explained that the UCC is going to govern this dispute and that the more liberal provisions affecting merchants also apply. I talk about offer and acceptance briefly, and then I focus on UCC 2207. Now, generally speaking, we're not responsible on the bar exam to know these statute numbers. On law school final exams, frequently you are supposed to know the numbers. I include the numbers for reference. But what matters here, the essence of what is at issue here, is not the number of the UCC provision, but what the provision is. And the rule is, as I've indicated already, when we've got an acceptance that is not a mirror image, absent an objection or a material change to the agreement, the new terms automatically become part of the agreement. So, finally, I'm going to conclude in favor of the motion to compel arbitration. Then we go to what really is the heart of the problem, the relationship and the obligations between buyer and seller. Here I touch on formation, and then I focus on breach. And notice that both parties are in breach. Seller is claiming that buyer's failure to make the next payment is a breach of contract. Buyer claims that seller should supply the exact order that seller has made. Then I turn to remedies and then finally reach a conclusion. So this is a very simple outline of issues because, in fact, the issues presented are comparatively straightforward and simple. So now please turn to have a look at the model answer that I've offered, and let's have a quick look at it together. You'll notice that the structure of the answer is directly responsive to the calls of the question. I am not trying to impose my own way of thinking about this subject on a question that itself is fairly specific. So, as usual, up front I lead with the facts. I indicate that buyer and seller have filed actions against one another arising out of a UCC contract between merchants. Then I focus on those details in section A of the first page. Then I turn to offer and acceptance and 2207. Internally, you'll see that really I'm doing a fairly effective job as a journalist. I'm explaining what happened. I'm finding a home for the factual details about the interactions between these parties. And when I conclude that the arbitration clause ought to be deemed part of the agreement, you'll see that I ground my conclusion in the facts. Not only did the seller never object to the presence of this arbitration clause, but seller, in fact, tried to invoke the arbitration clause before seller filed a lawsuit. So look at what's going on here factually. We've got a party, the seller, who's trying to have it both ways, who's arguing in favor of the arbitration clause up front, but then when push comes to shove, files a lawsuit. Well, our job is to analyze those facts and to reach a conclusion that is mindful of those actual details. So my conclusion is the arbitration clause is valid. Seller is not going to be able to escape arbitrating this dispute first. So then we turn to what I consider to be the real nuts and bolts of this dispute, analyzing the broader contractual relationship between these parties. So once again, my focus is on the formation and breach issues. Now, formation is at issue here. You've got to consider the exchange of letters in order to determine exactly what happened and when there is a binding agreement. But it isn't very complicated, and in the end, neither one of these parties can deny the existence of the agreement, and neither one of them can dispute the terms of that agreement. So then we turn to breach, and here is where I talk about each side of the dispute separately. Let's take a step back for a moment. Suppose we tried to analyze call of the question number 2 by having 2 separate lawsuits. It would be possible to work through the analysis that way and cover all of the bases, but it would be a lot harder to do so under time constraints. Taking it the way that I've approached it in this model answer, you'll see we've got plenty of time to cover all of the details and then reach a conclusion. Remember, there's no one right way to do this, and if you chose to organize this question substantially different from the way I did, that's fine. You can still write a decent answer. But I think you'll probably end up agreeing that the presentation that I'm making here is directly responsive to the call and doesn't leave out any of the issues between these two parties. So the seller's claim is that the buyer has to make immediate payment. And here, there are facts that can be used to reach either conclusion. My argument is, since the first 2 deliveries did conform, the 3rd delivery did not, and buyer objects to the 4th delivery, to me that's not enough to constitute a waiver of the term. One could argue the same facts and reach the opposite conclusion. I don't think it would be as good a conclusion, but it isn't unreasonable on its face. Next, the buyer is claiming a couple of things. Buyer wants leeway of time to pay. In other words, wants to pay not under the contract, but a few days later based on the course of conduct of the parties. And the buyer claims that the seller has to provide conforming goods that are directly responsive to the order presented by the buyer. Now, here, perhaps a little uncharacteristically, I find for the plaintiff across the board, I find that the seller has to arbitrate this claim. And when we get to the merits, I find that the seller has to accept a late payment and provide conforming goods. And as you look through the answer, you'll see that my analysis is consistent with that result throughout. Once again, I advise you, you don't necessarily have to agree with me. If you interpret these facts differently, you will reach opposite conclusions that will echo all the way across your answer, and that's not unacceptable. This question is going over some gray areas that are grounded in facts. As long as you are carefully analyzing those facts, the conclusions that you reach really are secondary to the breadth and depth of the analysis that you present to support your answer. So finally, my conclusion is seller is obligated to sell buyer exactly what buyer orders, and seller's got to wait a few days for payment. Ultimately, we require merchants under the UCC to behave reasonably.